Okay, so without further ado, let's continue with our first speaker, who will be Supervising Deputy District Attorney Cynthia Zimmer from Bakersfield, California. She is a prosecutor who has a lot of experience in using more advanced DNA methods to find truth in evidence. In fact, her office will not litigate a case, if I have that correctly, until the objective DNA results come in, so they know what the truth is before they can proceed. So I'd like to introduce Cindy, who will now tell us about DNA from her perspective.
Thank you. Good morning. Good morning. It's an honor to be here. I'd like to talk to you about the history of the type of DNA interpretation we do in California and give you a current status of what is going on there. I am from Kern County, California, and we have been a bit of a trailblazer in DNA interpretation, and we're very, very proud of that. I am the gang supervisor at the DA's office. I've been at the DA's office and been a prosecutor for 33 years. And in the gang unit at the DA's office, we're one county north of Los Angeles County. And at the gang unit at the DA's office there in Kern County, we prosecute the majority of the homicides. Most of the homicides are gang-related in my county. And so DNA is a huge factor in the type of prosecutions that we do with homicides, carjackings, robberies, and burglaries. So I will tell you that in Kern County, jurors now expect some type of DNA evidence because of what we call the CSI factor and because of the failings of eyewitness testimony in the past and what has happened and what we're seeing with the exonerations. So juries expect DNA evidence and they trust it. They trust it. There is a quote that I think is particularly interesting, and I found it because I'm also a teacher. I teach at a junior college in the criminal justice and social science department. And I found this quote, and I use it a lot in trial. And it really, DNA serves as a compelling silent witness. Wherever he steps, wherever he touches, whatever he leaves, even without consciousness, will serve as a silent witness against him. Not only his fingerprints, footprints, but his hair, fibers from his clothes, the glass he breaks, the tool mark he leaves, the paint he scratches, the blood or semen he deposits or collects. All of these and more bear mute witness against him. This is evidence that does not forget. It does not forget like a live witness would. It is not confused by someone who comes to court and becomes confused because of the excitement of the moment. It is not absent because human witnesses are. It's factual. Physical evidence cannot be wrong. It cannot perjure itself. It cannot be wholly absent, and only human failure to find it, study, and understand it can diminish its value. This was something that was written by Paul Kirk in 1953. And it's, I think, has a particular relevance now with the use of DNA, which Paul Kirk certainly did not anticipate would be used in courts of law 50 years later. Let me tell you a little bit about my county in California. I'm proud of my county. This is Kern County. This is where it is located. It is a large county geographically, not so much in population. It's the 11th most populous county in California, but it is geographically very large, about the size of New Hampshire. It is one county north of Los Angeles. Just under probably 1 million people now in our county, but like I say, it's very large geographically. It is in what is called the Joaquin Valley. So for the most part, most of our county is agricultural and oil-based, but as you travel east, up over a mountain range, it's the Mojave Desert. So we have a lot of space out there. The Edwards Air Force Base is out in that area where we have a lot of scientists. So we have a lot of people out there that understand DNA. You go south over what we call the Grapevine, which is Interstate 5, through a mountainous pass, you get to Los Angeles. So Los Angeles is our county to the south, but it is very different geographically. Even the climate is different. And then Delano is our northernmost city, which is actually the border between the Norteño and the Sereno street gangs and prison gangs in California. These are some of the things that from our county. We have oil, we have aerospace. The picture to the bottom left is our Tehachapi Mountains that you go through to get to Los Angeles. That's what it looks like there. This is what it looks like when you come over. I don't know if you can dim the lights at all, but maybe not. When you come over the Grapevine, coming from Los Angeles to go down into our valley, that is what it looks like, and then we have a lot of agriculture. So this sets the stage a little bit for the backdrop of why we were the first county in California to admit probabilistic genotyping interpretation. In fact, we were the first jurisdiction west of the Mississippi to have this coming into a court of law. We have our own crime lab. I work at the Kern County District Attorney's Office. District Attorney's Office are county-wide, our county. Our jurisdiction is our counties, and we don't share counties. Each county has their own prosecutor's office. And we, years and years ago, our lab started as part of the Sheriff's Department, and about 20 years or 25 years ago, our District Attorney's Office took over our lab. We're very lucky to have our own crime lab. We have independence, of course, but we also have a relationship with our lab. Most other counties in California use the state lab, the Department of Justice lab, and then, of course, private labs. Prior to 2012, we did what was called manual, or our criminalists did manual interpretation. We didn't use computers to compare a known reference sample with an evidentiary sample when profiles were done. And with manual interpretation, there is a requirement of thresholds. In other words, you can't use all the data. If it doesn't go up to a certain level, it has to be thrown out and not considered. And so what we were able to do for the most part were not mixed samples or touch samples, unless it was a very strong mixed sample with only 2 donors. But it was mostly blood, semen, saliva samples, not touch. The strongest mixture sample I ever had was in a murder case in which 2 people were drinking out of a beer can. And so you had 2 people, and that was the most elaborate mixture that I ever had. But it was saliva, and they were really good samples, and so it was a very good DNA result. But other than that, mixtures, it's not something we could do a lot with, and that was prior to 2012. And then in 2012, our county hosted a seminar, and it was in Kern County from all over the state, and Dr. Purlin from cybergenetics made a presentation. He was acquainted with the director of our crime lab, and we purchased the software and began the software for True Allele, which was probabilistic genotyping, in which the profiles were developed in the normal analysis, but then it's where the comparison comes in, and that is where the computer compares the allelic peaks rather than a human being doing that. And the True Allele uses all the data and doesn't throw out anything. So that was something that we were pursuing, and yet it had never been admitted into a court of law in California. So we started the process, a relationship with cybergenetics, where 3 criminalists began 6 months of training with assignments and reading and validation studies. In other words, they would take known samples and mix them and put them on an evidentiary item, and then swab them and look at the samples and do testing. And so it took a long time. We invested a lot in that process because we really wanted to do better. The lab validated the process, wrote some protocol, and went online. And then we decided, what case will we go to court on? What case will we try this on? So on a few cases, some of the samples were sent to cybergenetics in order to determine what to do a true allele, because we weren't doing it then, but we sent it to cybergenetics, and they did some analysis and some comparisons. And the first case was the people of the state of California versus Charles Lawton and Dupree Langston. And why am I involved? I didn't volunteer to be the person to introduce the first probabilistic genotyping. It happened to be my case. And the lab director called me and said, oh, by the way, you're going to court on this Lawton and Langston case? And I said yes, because even though I'm a supervisor, I'd still like to try cases. Well, we have this DNA result for you, and by the way, it is a new type of DNA interpretation, and we bought the software, so it's all on you. You're going to give it a try to have this admitted into court. I had just come off a 4-defendant first-degree murder case on a gang case, and had 1 month to get ready, not only on this case, which was a very complicated robbery case, but to make sure I didn't blow it on the admission of a new type of evidence. So it was really a challenge, but it was a great challenge for me. This case was an interesting case, and it wasn't a homicide, but they were serial robbers. They were a Crip gang called the West Side Crips. Now, Mr. Lawton on the left is wearing a Washington's national hat. It's not because he was a fan, because on the witness stand I asked him, why are you on social media wearing a Washington's national hat? Because I'm a fan of the team. Name a player. Name one player. He could not. He wears a Washington national hat because he's a West Side Crip, and that is a team that they like to they like to wear sports teams that displays something indicative of their gang. And then Dupree Langston, holding the firearm in his left hand, was also a member of this gang. And what these people would do would be to go to businesses, go in and commit quick robbery, take over robberies, and tie up usually the women in the business and strip them naked, and not sexually assault them, which was sort of an odd MO. And they did that, I think, to delay them and reporting it to the police, because a female's going to put her clothes on before she dials 911. And that took a little bit more time. And it was also particularly difficult for those victims because they had to lie there naked. And on one occasion, a man was stripped naked. And with his coworker that he didn't know that well, they were both naked, tied up together during a period of time until the safe could be opened, because some safes are on time delay. But this particular case brought some attention. There were the series in 1 month, there were 8 robberies in our area. But this case brought some attention because of what happened with the owner. And this was a nutrition store called the Max Muscle Nutrition Store that was in a nice part of town, near a very popular gym, near the 24-hour fitness. During this time, at about midnight, the owner of the store was in the store cleaning with his wife. They were cleaning the store, counting the money, and he had sort of an eye-catching car that was parked by the back door. And the back door of his business, the back door was slightly ajar, and he did not shut and lock the back door, but left it ajar because they were in and out this Camaro. Mr. Lawton and Mr. Langston were at an adjacent gas station. And there they are on this video that is seen, that is their van there, and they're getting gas and buying rolling papers inside at the 7-Eleven. And they were able to see when they were getting gas about 100 yards away, this Camaro with the back door of this business just after midnight open. And that was a very attractive thing for them to see, who by that time had committed 6 of these robberies. This is Mr. Lawton as he came into the business. This is what he had on. He was a big guy. He's a former college football player. And They saw the business, they decided to rob it. They changed their clothes slightly, and they went in, held a gun to the owner's head. They forced him to give the money. They wanted more money. The owner said, I think there's some more money in my car. They took the female into the bathroom, had her disrobe, held a gun upon her. But the owner of the business had a firearm on his person. He was armed. And so he was trying to take an opportunity, because he thought that they were going to shoot him, to shoot them. This is a picture of Mr. Lawton. He took off his red shirt and put on this jacket, and he has a hat on. This is the inside of the business. You see Mr. Langston quickly took over this is the owner here, and it's a little bit hard to see. That's the owner. That's Mr. Langston with the firearm in his left hand, with a hoodie pulled over his head. You can actually see a tattoo on Mr. Langston's hand that was, when you do some image enhancement there. There they have the owner on the ground. The victim's wife is in this room, and what happened is Dupree Langston came and went into that room, forced the owner's wife, who is a very beautiful woman who did quite a bit of advertising on television for this business, had her in there while Mr. Lawton was trying to get the money from the owner, and the owner talked Mr. Lawton into going out to the car to see if there was more money, and when he did, the owner pulled out a firearm and started shooting. He didn't have a round in the chamber, so he couldn't get off a round on time or in a timely way, but the two left the business and ran away. When the owner started shooting, he started shooting outside the business, and he started shooting in businesses in the area, and the bullet went and hit the gas station and hit the glass above the gas station and shattered it. And so there were bystanders in the neighborhood that were people around, and so this caught quite a bit of attention, and that a victim had a firearm, fired back, didn't fire and hit the suspect, but potentially put other people in harm's way by using the firearm. So there was a little bit of discussion about that, about when a victim is armed and so forth. So there were detectives from the Bakersfield Police Department, and in Kern County, Bakersfield is our county seat, and so these detectives, and it's our largest town, got involved in this and started looking at these robberies at different times, and they were smart enough to think, let's go look at the gas station video. They thought they recognized, because they worked in a gang unit, thought they recognized our suspects. So this is the view from the Max Muscle, and that's the gas station that the owner was firing at as they were running away, and there were people there at the gas station. And so there was some controversy about that, but it got people looking at this crime and looking at some of the others, because there's a lot of crime in Kern County. So that was the 7th robbery. 2 weeks before that, at the Advanced America in Delano, California, which is our northernmost city, there was a robbery, and these two went in and committed a robbery of this business. And here they are going in, because there was a fairly good video. They came into this business. There's a solo female working at the counter. Mr. Lawton, the larger one, went around the back, while Mr. Langston went up to the counter. She thinks they are coming in to transact business. And there's Mr. Langston going over the counter. Notice the gun in the firearm in his left hand. Counters are not really the greatest source of DNA. They make counters in businesses to stay clean. We don't get a lot of fingerprints or DNA off counters, but this particular victim had almost like a placemat on the counter that he jumped over with a plastic on the top that she kept clean, kind of a plastic vinyl type of thing. And you see where he placed his hand? Well, that right hand, the officers after the robbery went back and looked at the video and went and swabbed that area where his hand was. And that is where the DNA came from. There was touch DNA from his hand in that location. And this is the source of the DNA that was admitted into evidence for the first time in California, was this particular robbery. And I had this case. There were 8 different businesses, and we had a very good case. I had, I don't know if it's true out here, but in California, these gangsters cannot stay off their phones. And you would think if they are involved in criminal activity, they would not want to take pictures of themselves with firearms in clothing just before they commit a robbery and put it on social media, or even do it with their phone, because we can download their phone with Cellbrite downloads. So I had pictures of Dupree Langston in this shirt with this hat from his phone and from social media. And he's left-handed, and he's holding the gun in his left hand. So I had a lot of other evidence, but I had this DNA. I had this DNA from one of the 8 crimes. There was no DNA in the other 8 crimes because they had what they had touched, sometimes with gloves, they used gloves, and sometimes with a counter. So this was one of the samples that was sent to cybergenetics, in which there was a, I know scientists don't like it, but DAs like to say the word match. We like to call it a match, but and there's a statistic involved, and with true allele, that's a likelihood ratio, and the statistic was not huge, but it was pretty good, 553 million times, which, and Dr. Purlin called that a strong match. And you see the 553, we call that an 8, because that's like the 8th place settings in math, and I'll talk to you about that. The 553, you sort of count the zeros. Is what you do, the place before you get there. And so this is just an example for those of you that haven't seen some of the profiles, the electropherograms, of what, this is a reference sample here, and you can see the allelic peaks at each of the loci. This is just 4 of Mr. Langston's genetic profile, and this was the evidentiary sample here. And you can see that there was a mixture, especially on the first, you see all the peaks. Well, in that evidentiary sample, if we had looked at that manually, some of those peaks would have dropped off and you couldn't consider them because they were below threshold. But with the computer interpretation, in which it interprets all the evidence, you could use all the information. As you can see, this is a 1415. You can find that here in the evidentiary sample. You can see Mr. Langston here, and here, and here. And so we were able to introduce this evidence, but we had to do what we call in California a Kelley Frye hearing. People versus Kelley is a California case. Frye is a United States Supreme Court case. And so this, for those of you that don't know the Kelley Frye rule, if you've never done one, I'd actually never done, I've been a prosecutor there for 33 years. I'd never done a Kelley Frye hearing. Not that I can ever remember. I know I argued against Kelley Frye a few times by saying, oh no, we don't need one in this case. And so I had, but usually all the scientific methods that I had ever done had already been established. What is the Kelley rule? Has the scientific method gained general acceptance in the field? Is the witness an expert that was qualified to give an opinion on the subject? And was the correct scientific method used? Well, this was a long trial. It took 4 months to do this trial. And because we had a number of incidents, there was the gang enhancement. I don't know if any of you have ever prosecuted or defended gang cases, but the gang enhancements, it's almost like a trial within a trial. You have to show that the defendant is a member of a criminal street gang, and that the crime that was committed was for the benefit of, at the direction of, or in association with a gang. And there are hoops that you have to jump through in order to do that. So gang trials, at least in California, are lengthy. How did we do this? Well, we had Dr. Purlin come out and testify. We had no precedent. We had no legal precedent. There was one case in Pennsylvania, the Foley case, that was used but not controlling authority for us in California. And we used that case and hoped that the judge would be persuaded by that, but we didn't have any legal precedent. So it was a case of first impression, not only in our county, but in California. How did we do the Kelley Frye hearing? Well, we got a binder, and we stuffed that binder full of things. And I have some of the information that I have for you talks a little bit, it's a motion that talks about the different publications, but we did a binder, we did a tab called publications, and we put the publications in there. and validation studies and approvals from regulatory agencies, forensic applications, validation papers, defense commentary, and judicial opinions. And we made a binder full of those, we described them, and we gave those to the judge, and we had our expert witness talk about them. Normally, a Kelley Frye hearing would be done during what we call a 402 hearing, or an in limine motion. We did not do that in this case because it would be expensive in a 4-month case to bring our expert witness, who was Dr. Purlin from cybergenetics, out twice, to fly him out twice. So what we did in this case, and this case really lended itself to that because I probably could have convicted Mr. Lawton and Mr. Langston without the use of DNA evidence. I had enough circumstantial evidence, telephone evidence, shoe tracks, different things in that case that I probably could have done it, although we didn't have admissions. But, I had the tattoo on the younger man's hand and his left-handed. There was just a lot of evidence, clothing. However, we were able to do that. We brought him out mid-trial. We didn't mention anything about DNA evidence in opening statement, nor did the defense. During the middle of the trial, just before the DNA evidence that we intended to present it, we took a recess from the trial and did the 402 hearing and had the jury outside the presence of the jury, gave them about 2 days off. And we did our 402 hearing then, about 3 months into the case. And Dr. Purlin came out. We did a Kelley Frye hearing outside the presence of the jury. And it was a lengthy hearing, and we prevailed. The defense did not call an expert. We did not have an opposing expert for this case. Their method was to attack the reliability of Trulio just through cross-examination. There was a conviction in this case, and we were hoping that our appellate courts would review this and we could get a published decision. We did not. The way it works in California is you have your trial attorneys, you have the county prosecutors, and we had public defenders and appointed counsel for this case. Then when it goes up to the next level, we have a trial level and appellate level in our California Supreme Court. Our appellate level is in a town called Fresno. We don't have an appeals court in Bakersfield. It's kind of a Joaquin Valley towns. Our appellate court is in Fresno. And the appellate lawyer, who was a different lawyer than the trial lawyer, did not appeal the DNA evidence. I don't think they thought, my speculation is, I don't think they thought the defense set it up in a good enough posture to be able to present that at an appellate level, and it did not address the DNA. So we were very, very disappointed because we put a lot into the record to have we thought, a perfect Kelley Frye hearing. And the judge made, I think, an intelligent ruling. So for a prosecutor, we were disappointed that we did not get an appellate ruling because we were still in the same position that we were in, and we were using true allele then after that. Our lab was using true allele then, not on every case, but on many cases. In the meantime, our lab began a validation study and did a validation paper. That validation paper was published in the Journal of Forensic Sciences in 2015. And that is a very well thought of publication in the scientific world, especially the forensic science world. Here is the paper, and it was the paper was done in connection with Dr. Purlin and 2 of our criminalists from our crime lab. Here's the title of the paper. True allele genotype identification on DNA mixtures containing up to 5 unknown contributors. So that was very helpful for us that our lab was involved in this validation study, and we were the ones that were first in California, first west of the Mississippi, we like to say, in introducing probabilistic genotype and DNA interpretation. And so it was accepted for publication a year or so before it was actually published, and that helped in the next case where DNA really made a difference. And that was in the case that I tried in 2015, and that was People versus Billy Ray Johnson. This is a picture of Mr. Johnson from social media. Okay. Now, Mr. Johnson actually was a gang member. He was a Crip. But I can tell you, gang members don't usually rape. Okay? It's not really very well respected in the gang because gang members have enough swagger to get the women that they don't really need to do sexual assaults, and it's not very respected. But what Billy Ray Johnson was a hot prowl burglar. And if you don't know the term hot prowl, what it means is going into the homes of people at night when they're actually in there and asleep, and doing it so effectively and quietly that they can go in and burgle and never be detected and get out while people are asleep, rather than when they're at work, which is the normal burglar. Well, he became so good and accustomed to that, years and years of being a hot prowl burglar, and plus he was had some sort of issue, began to rape women while he was inside. He probably saw enough of them sleeping. In this particular case, it was very, very, got a lot of attention because it was, women were being raped in a very small area of town. They were single women, many of them Hispanic, and I think there is a perception that some Hispanic people, we have a high degree of Hispanics in Kern County, that people who are undocumented immigrants will not report crime. So if they don't report crime, you can get away with what you do a little easier. So we're trying very hard to get undocumented people to report crime through various methods. But they would be single women with children that were targeted. And so it was causing a lot of concern because stranger rapes in our county are highly unusual. They are highly unusual. They are rare, one a year, if that. This was called the East Side Rapist, and everyone in East Bakersfield was on guard about this. In July and August of 2013, he was breaking into the homes of women at night. They would be asleep in their bed, and they would wake up with a masked man on top of them. He would, "Don't move or I'll kill your children." What woman wouldn't do anything in the world she could do and be as quiet as she could to spare the lives of her children? He wore a mask, a hooded sweatshirt. He brought in zip ties for handcuffs and duct tape for the eyes. He would tie them up with zip ties, sexually assault the women, and then afterward wash them in the shower to get off what he thought would be the DNA. When we downloaded his cell phone and looked at his Facebook, we could see that his favorite programs were the CSI-type programs where he was able to get information about real cases in which there was DNA. He knew about DNA. No victim ever saw his face. We had 4 different households with a number of women in the household. This is the first victim. She was 17 years old. Her mother had gone to Mexico, and she was a college student, and she was home alone. There was no call out by crime scene people from one of our departments, so there was no forensic evidence collected in this case, the first case. But she lived in an apartment complex. This complex where he came in the back window, and the 2 ladies there couldn't hear him, and then woke up with him on top of them. The second female, her husband actually had gone off to work. She lived in an area where our rapist used to live in the same complex, and she was tied up and raped as her year-old baby slept in a crib nearby. This was her apartment in which he came in the back window. This particular case was so egregious. This is our victim. And this is, I think I have a 911 call here, and she was there with her 3 little girls. See if I can put this on. This is in Spanish.
Sí, es que me estaba esperando cuando yo salí al trabajo. Me estaba esperando y cuando abrí la puerta él me pichó, me aventó para adentro. Me amarró y luego amarró a las niñas.
Okay. I hope you can read that. Basically, she doesn't want to report what he did to her, but she's talking about she was a maid in a hotel, and when she opened up her door to go out, he pushed her in, And why he didn't come in her window is that she had a burglary a few days before, and most likely it was him. And she had put dowels in the window, and he couldn't get in the way that he had come in before, so he waited for her at the front door. This was in the same apartment complex as attack number 1, just around the corner. So, oops.
Que no se llevó nada, pero tienen que venir porque él hizo más cosas en el apartamento.
She was from Mexico, and this is really, I mean, it's humiliating for any woman to be sexually assaulted. But it's very difficult for a lot of people who aren't quite as sophisticated in some ways, and she just couldn't even tell them on the phone what had happened to her. But it was the same complex. And then and the police were not able to catch him, the same method, tied up with zip ties. And then on our 4th case, we got a break. And when Mr. Johnson would come into the homes, he not only would bring zip ties and take them out, he would pack up the evidence and take them with him, but he'd also go in and get the cell phones. He'd get the cell phones so people couldn't call on the cell phone or the house phone. And in this case, he assaulted the mom, put her in the bathtub, tied up the 9-year-old daughter, put zip ties and duct tape over her eyes. But the 9-year-old, who is one of the biggest heroes I've ever seen, she testified in court holding on to a teddy bear. She was able to get out of the zip ties, take the duct tape off her eyes, and get to her phone. She had a phone by her bed that looked like a toy, but it was actually a Disney princess phone with like Belle, Cinderella, and little decals on it. It was a real phone. And the rapist either didn't see it or thought that it was a toy. But this is the 9-year-old when she calls 911. And she had heard some things going on in the apartment, but she thought it was her dad. Her mom and dad were divorced and thought it was her father. Oops. Try one more time. There we go.
911.
Hello, 911.
Yes, this is Scott. He has my mom naked.
Okay.
He had me blindfolded.
Okay, how old are you?
9.
9. Where's your mom at now? What?
She's not with Dad. She's not with Dad.
Okay. I don't know if you could hear all that. She says, there's a guy, he has my mom naked, he had me blindfolded. And the 911 operator, we were looking for him. There she is, there's the neighborhood, and there's the call. And so she was able to get out of her zip ties, make that call, and then he heard her and caught her on the phone. And she's saying, you're not my dad, because it is the realization that the man's voice she heard in the night was not her father, with whom she was very close. So he caught her, but he was more concerned with getting the phone away from her, and she was able to run and escape to safety. And he knew, because it was all over the newspapers, that we had a rapist in this particular part of town. He gathered up the zip ties, he gathered up the duct tape, he put them in his backpack, and he ran out, and he ran because he lived in the neighborhood. So he was running, but he dropped a zip tie in the parking lot. Here is the apartment. This is the apartment where it happened. And this area down through here where there is a field going east, that's our Sierra Nevada back there. There was a zip tie. And a law enforcement officer saw it out there in the parking lot and picked it up. But protected it for the most part, and the wind was blowing and picked it up. Now, we call this the road zip tie. At each of these 3 scenes, because the first scene we didn't have anything collected, law enforcement took everything in the apartment. They swabbed everything, they took the evidentiary samples, and we ended up hoping they would get some sort of DNA sample from someone. And so we can't test every single thing. I think those of you in the business that are at the labs know we can't do that. So what our lab director did is sat down in meetings with law enforcement officers from each of those 3 departments and looked at what where would we be able to find DNA? Where would we be able to find it? Because the victims felt gloves. You know, they were blindfolded. They felt gloves. And then at times during the rape, they felt a bare hand. So at some point, we believe he most likely took the gloves off. So the lab director looked through things, talked to law enforcement, and that's why I think it's really important that we have communication with the lab and law enforcement. What would be the items that would be most likely to yield DNA based on the facts of the case, because you can't test everything? Well, that zip tie was one of the most important things, and there was enough DNA profile on that to put it in CODIS, and it came back to Billy Ray Johnson. Well, having a zip tie out, not in the apartment, but outside, is not enough evidence to make an arrest, because he lived actually in the neighborhood. It's not enough to show, because there wasn't anything else to link him to that particular attack. So there was no arrest made, but law enforcement started following him. They started following him, and to make sure that nothing else happened if he was the person. The data then from that item, as well as others, was then sent to cybergenetics. And I think they made this a priority and started looking at DNA samples, because there were some profiles from some of the items that were located. Law enforcement started surveilling him, but they lost sight of him in a neighborhood. It was this neighborhood, and it wasn't far from where he lived. And later on, we were able to download his cell phone, and he videotaped the woman that lived in this house as she was getting ready for work through the back window, and she was naked. And he did not attack her because he was arrested within that night, actually on a different charge. But I wanted to show you, I'm not going to show you the video of her nude because that was, heavily redacted, but also on his cell phone, he had this video. What do you think he's doing? He's looking for a key. Okay. I've got to tell you, I found that house. That was not charged. That was what we call 1101B evidence, other bad acts, other crime acts. We were able to put that evidence on, and I found that law enforcement was like, oh, that's going to be hard to find. But some of the attorneys and I in the office, with the use of Google Maps, we started looking at that, and we went out, and we really thought we were detectives, but we went out, we found that map, we found that plant, we found the woman, we knocked on the door, and because mind you, this was a year or two later. We found it, we brought that witness in, found that house, and also the lady. We knocked on her door. Hello? Yes, we got to show you something. Is this you? And we showed her the videotape of her nude getting dressed, and she started screaming. I was like, oh my, and she came to court. She was a very gracious, lovely woman that came to court. So they started watching him, and then he was a gang member, and he was at this party, and from a distance they saw him shoot off a gun. He was a felon, and they arrested him for being a felon with a gun. And so that gave us a little time to finish our DNA without having to follow him. All right, from scene number 2, where did we find the DNA? The DNA was on the purse strap that he used from the little child's purse, that blue strap. That is what the woman was tied up with. And so there was DNA there. Her cell phone was moved and hidden and placed under her couch cushion. And this was a phone cord that was brought in and left there. It was not the victim. She looked down and saw this. It's like from a landline phone that was left there. That's where we found the DNA profiles that matched Billy Ray Johnson on those 3 items. It's scene number 3 where the motel maid was raped. On number 2 and number 4, the defendant wore a condom. On crime number 3, he did not. He had her hog-tied behind her back with her arms and legs in zip ties. She was face down on her bed, and he pulled her black pants down, her blue shirt up, attacked her, probably wiped off with a towel, and then she pulled her clothes back up, and there were semen stains on her black pants and her blue shirt. So there were some stains there that yielded the DNA on the inside of her pants. That we had some semen there, low level, and then we had the zip tie, and then this bathtub handle yielded DNA, a swab of the bathtub handle where he put her in to wash her. Okay, so what are some of the stats that we had out of this case? Very low. You would never get any type of DNA match with traditional or conventional manual interpretation. The purse strap, and this is the way the chart reads. This is the victim's DNA, her husband's DNA, and Billy Ray Johnson. Sorry, the yellow, it doesn't show up very well. But on that purse strap, our statistic was 43. 43. In our lab with True Allele, we don't report anything as a match. It's inconclusive if it's under 10,000. Okay. But the match there was 43. So you know what he's doing? He's using gloves to get in the apartments so he doesn't leave any traditional DNA at the point of entry. But when he has to do things with his fingers, like use zip ties and that kind of thing that requires dexterity, he takes his glove off. You know, when you're doing gardening, you have gloves on, you have to take off your gloves. That's where we were able to find the DNA when he touched things. That phone cord that he brought in and forgot that he was probably going to tie the victim up with didn't have any of the victim's or her husband's DNA on it, but it had his, but a low level, 34,000. That is a very low likelihood ratio statistic. But still, it was admitted into evidence. And then the cell phone, also a fairly low ratio, a likelihood ratio, but it was still some DNA that connected him to that particular crime. The sperm from victim 3 on her pants and so forth, this was interesting. She had had intercourse 3 or 4 days before with her boyfriend. So this was a mixture. And there were no swabs from inside the vagina. They were on the clothing, the stains on the clothing. And so she had a mixture of, and so this is how sensitive this is. Semen that's 3 days old. That's so it's kind of gross to have to go through like how that would get on her clothes, because he's not using a condom. He wiped up afterward, but he pulled out the semen from the boyfriend that was there from several days before, because those stains were on clean clothes. She was a motel maid. She just got them out of the laundry that she was wearing on her way to work that morning. But you can see the samples. The boyfriend, as far as semen, was a quadrillion. Billy Ray Johnson was 1 million. Here's stain 2 on the pants, quadrillion and 1 million. And on the shirt, it had her DNA, as well as quadrillion and 1 million. So the shirt had her DNA, but the stain on the pants was just a sperm sample from both of them. And then on the 4th one, where we had the 911 call, on the bathtub handle, we had a statistic of 550. But the roadway zip tie, the one we were able to put in that was the key to our case, he probably brought that, from home and had touched it beforehand. We had a good statistic of quintillion. But look what True Allele was able to show us. She was on the zip tie. That was the key. It wasn't him just dropping it in the roadway. We didn't have that with traditional DNA. She was on the zip tie. Yes, not very much, 1,000, because it's actually not the zip tie he tied her up with. The zip tie that he tied her up with was in the bathtub, because she was still handcuffed as she sat in the bathtub as she heard her child screaming. And he was actually dunking her under the water. This is a zip tie he probably touched her with, intended to tie her up with, perhaps took it away from there. So that's the statistics. What was interesting, and I hope I'm doing all right with my time, I think so, is that since this was our first major case with probabilistic genotyping, yes, the Lawton case that came into evidence, but this is going to be one that we knew would be looked at, because this was our case. DNA was our case. Dr. Purlin came out and testified as to his results with True Allele, but our lab did as well. He ran his own statistics, our lab ran ours, and neither knew about the other. So Dr. Purlin didn't know what our criminalist statistics were. And our criminalists never knew, during the whole time during the trial, they never knew what the other was. But we knew. I knew as the prosecutor, and I couldn't tell the other, so that was a little bit of a challenge because I couldn't say, Dr. Purlin, our lab did such and such and got this result. So, you know, we had to keep a wall because we wanted to really protect the integrity of the evidence and the findings, because we were in the fledgling time of this probabilistic genotyping type evidence, and we knew it was going to go up in appeal. But they had concordance, and concordance meant, remember I told you that particular number, what we called it an 8 because of the number of zeros. Concordance is considered within 2 zeros. So our lab made certain reported out findings, as did cybergenetics, and our lab, cybergenetics is a private lab, and they don't have to not report things under 10,000. They just report what the statistic is and drawing conclusions. But the interpretation with our lab and cybergenetics, they were all concordant, using the genotype with completely different operators, making assumptions, totally different people, but they were concordant, which really was quite compelling in court. These are the items in the second sexual assault case. The first one where we had DNA, and we got profiles outside the window, inside the window, the purse strap, the phone cord, and the cell phone, and also vaginal swabs. But since he wore a condom and used gloves, we didn't find any of Johnson's DNA. Where we found it is where he took the gloves off, and you can see the two different, the results. The victim here, Dr. Purlin's result, we call it a 19. And the victim with Sugimoto is our lab. His name is Garrett Sugimoto. So that's the Kern crime lab. So cybergenetics versus the Kern County lab, look at the similarity, a 19 versus an 18. And you know, that's a lot of zeros, right? That's huge. And so we felt concordance, or we were told concordance was within 2. The husband was on the purse strap as well, a 6 and a 4.81. And Johnson was a 2 and a 0.8 and a 0.9. Now, when you do true allele testing, sometimes you will do 2 or 3 runs. Our lab takes the lowest number. And so that's where you'll see our lab being a little bit lower than Dr. Purlin's numbers, who he reports what he feels is the best run. And he invented the system, and it's probably has his and he talks about what he feels to be the best run. And the cell phone, we had the victim's DNA on the cell phone. The husband was on the cell phone, as well as Johnson, a 5 and a 4. So it was again very compelling that you had 2 different labs looking at it, and then neither knowing the results of the other, and they came in. The same with you can see highlighted in yellow, we had DNA matching our suspect on the 2 stains on the pants and the shirt, and those were all concordant there, a 6, a 7, and a 9. And it's a 4 that is 10,000 or lower. So the sperm was above even our threshold. And the bathtub handle and the roadway zip tie, which is the big one. That's a 20 and a 20. And here, her DNA was a 5, and our lab reported a little higher, 6.7. What are the trial motions and legal issues? Well, on the Billy Ray Johnson case, I argued that a Kelley Frye was not needed because that time, it was about 2 years later, that in our jurisdiction, true allele had already been admitted 5 times. Now, the first time is the time we did the Kelley Frye, and that's the only time we did one. And the other cases that true allele came in were cases actually that really weren't all that contested by the defense. They were cases that helped them, because a lot of times our DNA really does help the defense. Sometimes it wasn't an issue, DNA wasn't an issue, and they had really not been contested, but still there had been no published opinion. So the pretrial motion I made was that I'd like for the admission of the DNA evidence and that no Kelley Frye was needed, and that was granted. No Kelley Frye was done by the judge. But then the defense made something that was called discovery of the source codes. and this is where it appears to be going in California. The litigation is the source codes, or the formula, what was used, the mathematical formulas, and coming up with the computer program. The defense made a motion for disclosure of the source codes. I fought that on the issue in the motions. You have access to them. People call me for these motions from all over the U.S., and I send them to them. The source codes, we argue, are privileged because they are a trade secret, and the defense did not make a proper showing of how that would be material or necessary, because they had an opportunity to perhaps get discovery of those if they could have articulated a sufficient reason as to how that would have helped them in revealing the source codes and what they could have done with them. The argument for our opposition to reveal the source codes was that true allele was validated, and again, I have all the arguments in the paper if you'd like to see it. It was reliable. What was the defense able to do with the source codes, if they even had them? Did they have an expert that wanted them so they could look at them and understand them? The defense did not present that in our case, that they had an expert that even had been trained in probabilistic genotyping. They didn't have that. They called an expert that was someone that had worked in a crime lab several years before and that did manual interpretation and never had any training in this area. And we talked about how there are a lot of machines that are used in science, and no source code case that we could ever find had the source codes ever been revealed. So we prevailed on that motion. The defendant, here's it was on the front page of our newspaper that our East Side rapist was convicted, and it said that he was, talked about his sentence. He actually got LWOP. In California, LWOP, life without parole, that sentence is reserved for those who commit homicide, what we call special circumstance homicide. But there's also something called one-strike sex crimes, in which enhancements are given to those who commit a sex crime in which they break in to a home, if they bind the victim, if they gag them and do certain things, and molest a child. So that carries LWOP. It doesn't if you rape an adult by doing those certain things, but if you do that and molest a child. So on the molestation of one of the children, the defendant was sentenced to LWOP, life without parole. So this case is on appeal now, and this is our case in California that everyone is watching. So lucky me, I didn't. Anyway, thank you, of course. But so this case is getting publicity. It is being watched. What are the issues? He got quite a bit of time in California. LWOP plus 432 years. What are the defense arguments on appeal? The first one is a source code violation by the court refusing to allow access to the source code that it violated his Sixth Amendment rights to confrontation and right to a fair trial. And so this is the one what we're looking at, and this is the one that we hope to get a written opinion on. And second, the defense did call an expert in this case, but it wasn't someone trained in this type of DNA analysis. They hadn't received the training, and so the judge curtailed a lot of expert testimony on true allele, because she actually wasn't curtailed from testifying by way of 402 hearing. It was apparent when she started testifying that she was misinterpreting the evidence. She started testifying about the runs and that kind of thing quite recklessly, really. About certain things, and at that point I was successful in shutting her down, basically, about talking about it, because she just didn't have the sufficient knowledge and training. There are people in California and throughout the United States who are sufficiently trained in this, but the defense chose to call this particular person who had done DNA in the past. So this is what we're looking at. The case is being handled by the California State Attorney General and the appointed counsel for the appellant, but there are friends of the court brief that have been filed by the Civil Liberties Union, the LA Public Defender's Office, the Electric Frontier Foundation, and the Northern California Innocence Project at the Santa Clara University School of Law, the California Innocence Project, and Loyola Law School Project for the Innocent. That's my law school, Loyola. It's like, really? And I know there are people out here from the Innocence Project, and that's great. But anyway, when you spend 4 months in trial and a year working, on this case, my heart was in this case, and I have complete confidence in the integrity of this evidence. There was other evidence as well, cell phone evidence, shoe track evidence, description, and so I'm very confident that we have the right man convicted of the right crime. But we are going to be looking at this as a legal issue regarding probabilistic genotyping and revealing source codes. So that's where it stands. This is, I think, for us in California, the case to watch. It's a case that I think will probably go to the California Supreme Court. Whatever the decision is, I'm sure both sides, regardless of what our appellate court decides, it will go on. We continue to use true allele. We continue to use it when we are solving cold cases with true allele. We haven't had situations regarding any exonerations yet, although that potentially could come in our county, but we haven't had any that we know of with the use of DNA that I'm aware of yet. Here we are. We're very proud of our gang unit. It's a big unit. This is us doing some press conferences, and I am the only female in my gang unit, and I'm the boss. So, not that that makes a difference, but this is a group picture of us, and we are very passionate about what we do for helping victims of crime, who are usually people who are impoverished, usually people that don't speak English, and that we are able to be their voice in court. So that's my presentation. I hope it has been helpful for you knowing what's going on in California, and for those of you that can see it from a prosecutor's perspective, maybe a little bit different perspective than what you're normally accustomed to. So thank you very much for your attention.